Thank you very much. May I use the opportunity on behalf of the committee to welcome Justice Sir Dennis Dominic Adjei, Justice of the Court of Appeal. Our members, based on the list of the nominee, he happens to be the second person, hence the second person to be vetted. I will proceed to ask the nominee to tell us about his background briefly in 2 minutes.
Thank you, Honorable Chair. My name is Dennis Dominic Adjei. I was born on 25th of March 1964. I attended SUPREME RC Primary and Middle School. Then I continued to Achimamman Secondary School, now Ifiakobi. Then I proceeded to Wenchi Methodist Secondary School. Then I went to Legon. I did law. Then I went to law school. I completed in 1993. I practiced as a lawyer. I set up the Holy Trinity Chambers in Kumasi. And Ashanti Region Bar, I became the vice president and the president of the Ashanti Region Bar. Then after that, I joined the bench in 7th of July 2010 with my colleague Justice Senyon. We joined the same day at the Court of Appeal level. And the Court of Appeal, after assumption of office, 6 months, I was made the director of the Public Complaint Unit of the Judicial Service. Then I proceeded. Later on, I became the head of the Judicial Training School, JTI, where I served for 5 years, and I was recalled to come and do another 2 years. Then I've served on several committees, including the appeal records. I've been the chairman. Then I've been a supervising judge, oversight judge for almost all the regions, with the exception of Accra, Eastern, Volta, and Ho. All the others have been oversight judge before. Then in addition to that, I proceeded to hold several positions, such as Dean, Faculty of Law, Gimpa, as an additional duty. They requested the Chief Justice to nominate me to assist. It was additional duty. Then I did it. Then international levels, I have, before I moved to international levels, I'm a fellow of the Ghana Academy of Arts and Sciences. I'm also the fellow for the Inns of Court Fellowship for 2022. I've been the chairperson for the African Judicial Network on environmental law. I was the first person to be elected president when we met in Mozambique. Then I've also been one of the 9-member advisory committee of the International Criminal Court. We vetted judges or candidates becoming International Criminal Court judges. And my term expired 6th of December just last year. Then I'm one of the 11 members of the African Court on Human and People's Rights. And I am in my 3rd year. I was there and I came just last Saturday because of this vetting. In addition, in terms of education, GIMPA, I did Executive Master in Business Administration. University of London, I did postgraduate diploma in criminology, postgraduate certificate. Then I did Master of Laws in Criminology and Criminal Justice. Then I went to Duke, where I did MJS, Master of Judicial Studies, where I specialized in interpretation of law, judicial education, and judicial management. And I have taught at the law school for 15 years. In 2016, UCC, University of Cape Coast, appointed me as an adjunct associate professor. In 2022, appointed me as a full adjunct professor. Kwame Nkrumah University appointed me as associate professor part-time in 2016, and I've been teaching in that capacity up to date. So, Mr. President, Chair, you said brief, so I will just limit myself to these things.
Thank you very much. I said brief in 2 minutes, but looking at your 18 pages CV, I wonder how you could do that in 2 minutes. So I've decided to give you a bit of time. Thank you very much. Honourable members, we will then proceed to conduct the vetting I will start by giving the floor to subject matter committee members. So, Honorable John Darko, you have the floor.
Yeah, thank you very much, Mr. Chairman.
The rule still apply.
Thank you very much, Mr. Chairman.
One question.
My Lord, congratulations. My Lord, I've read a lot of your judgments, but there is this particular one that piqued my interest. My Lord, the case is Etilesi Company Limited and another versus Attorney General. This is a decision of the Court of Appeal dated May 2023. My Lord, you delivered a unanimous decision and denied an appeal from the High Court by the appellants, whose application to the High Court for yes, Court of Appeal, yes. So you refused the appeal from the High Court by the appellants, whose application to the High Court for extension of time to invoke the fundamental human rights jurisdiction conferred on the High Court. That decision had been dismissed, the application had been dismissed, and when it came before you, you refused it. Now, as a member of the African Court on Human and People's Rights, don't you think that the interpretation you placed on Article 33 and Order 67 of the rules, within which to... So my question is, my Lord, as a member of the African Court on Human and People's Rights, don't you think that the interpretation you place on Article 33 and Order 67 of CI 47
my learned friend, is it the interpretation the court placed or he personally placed?
It's the court, of course.
Very well.
But I mean, he read the unanimous decision, yes. You know.
That is the court's decision.
Yes.
To ask your question.
I know my Lord is capable of answering this question, you know. So I'm just wondering, don't you think that that decision rather will make it difficult for the vulnerable in the society to have difficult to access the courts, especially if you look at the fact that some people may get to know about the violation of...
Honorable member, you have asked your question. Let me ask the nominee to answer the question. Please. My Lord, your answer.
Honorable Chair, human rights, we talk about human rights, it is time-bound. If you have a look at Article 33(1) of the Constitution, it says that it must be a right that is related to him, and it is being, has been, or likely to be. And rules of courts under Order 67 has construed, has occurred to mean 6 months. And it does not mean that if you do not invoke the court's jurisdiction within 6 months, there is nothing you can do. It is human rights application that cannot be brought. Your action will become common law tort, wrongdoing, and therefore you go and issue a writ instead of taking benefit of human rights application, which is held expeditiously. That is what it means. It does not prevent people from accessing the court, but they must respect time. Thank you, Chair.
Yes, any follow-up question on this?
Yes, Mr. Chairman. I know my Lord serves on the Court of Human and People's Rights, and my Lord rightly stated that you came last weekend. Your term will expire in 2028. If you can explain to this committee how you juggle your position as a member of the African Court for Human and People's Rights and our Supreme Court, I think will be very helpful.
Yes, my Lord, the question is overruled. This cannot be a follow-up question. I will then proceed to give the floor to Honorable Tampoli.
Thank you, Mr. Chairman. Good afternoon, Honorable Justice Dennis Adjei. I would want us to continue on an exercise that started with your brother, Justice Senor Jamefe. It was inconclusive. Had to do with the scope and effect of various clauses under Article 60. That has to do with the succession architecture, so that in the absence of the president, the vice president shall act, and in the absence of the vice president, the speaker. Now, what if we have all three of them absent from the jurisdiction around the same time? Various schools of thoughts, have expressed different opinions. I have seen that you have a book titled Approaches to Interpretation, Purposivism, Living Constitutionalism, and Intentionalism in Ghana. Major setback in constitutional interpretation as a matter of public law and rights in Ghana, published by LexisNexis. I want to tap into your rich experience in terms of the application of the purposive application to this particular provision of the Constitution. Do you think there's a lacuna?
Thank you, Chair. In addition to what you have said, that article, I have 7 other books. Most of them have discussed these things. Yes, when we talk about the absence of the president, there is something in interpretation which we call capping legitimacy, meaning that whenever you are interpreting or wherever you are providing events, it should end somewhere. So here, if you look at the intention of the lawmaker or the purpose of the law, at any point in time, one of the three must be in Ghana. You cannot extend it to the Chief Justice because the law does not say so. If you go to Article 57, precedence, where the law wanted to say so, the law said that precedence, in the absence of the president, it is the vice president and speaker and Chief Justice. That one is about precedence in the absence of this. But when it comes to, in the absence of president, vice president, speaker, in terms of governance, it is not the duty of Chief Justice. It was Professor Kruji who, in the case of Asare as Attorney General, 2003, 2004, expressed a decision which was not ratio in the matter. It wasn't the ratio in the matter, in which he stated that to him, in the absence of the speaker, it should be the Chief Justice. It was a personal, it cannot be a ratio. Because if you read it, it is an obiter, and obiter does not bind any court. Because that was not the issue before the court. So my simple understanding is that it is to give legitimacy and to end the cap. So the cap has been fixed, the three. Because why do you go? So in that sense, you also go to say that in the absence of the Chief Justice, then in the absence of that person, then what is the essence of providing for leadership in your country? That is the essence. Thank you.
Thank you very much.
Thank you.
Any follow-up?
That's right. So, by your interpretation, what if by necessity, and there is a Latin maxim that says that necessitatis non habet legem. By necessity, we don't have the president in the jurisdiction. Maybe the vice president has been taken ill, and then the speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
Well, I will allow.
It's just an academic exercise.
I will allow the supplementary question subject to the aspect that says the vice president is ill, because the Constitution used the expression absent from the jurisdiction. So, my Lord, you may proceed to answer the question.
Thank you, Mr. Speaker.
Thank you. You know, there have been 2 Supreme Court decisions on what do we mean by absence of the president, vice president, or the speaker. And it is the interpretation that has been given. And to me, that interpretation to me, contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And We talk about purposive interpretation. Purposive interpretation means we look at the purpose, and the purpose is determined by time, circumstances, and development. The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future that there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time, and the meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to Honorable.
Last follow-up. Last follow-up.
Bafo.
Mr. Chairman, aren't you enjoying the
discourse? You have exhausted your limit. The majority leader wants a follow-up.
Yeah, but Justice Dennis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president, and for what duration they can act as president. So what could have necessitated an obiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asare vs. Attorney General, which I personally, even though it is an obiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him, because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were signed into law by the Chief Justice. That was the position then. So he used that one, because that regime, the order in council 1957, is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at it, he was influenced by that position. But within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice will sign to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person, or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes? The executive. If if it extends to Parliament, there's nothing wrong because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you, from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader, do I take it that you are now having your turn?
Yes, I'm having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation?
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., chair a cabinet meeting where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, you know, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction. And if you look at the decisions rendered by the Supreme Court, the one against Honorable Adjei, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president? He's there in his capacity as president, sometimes even on a state visit in his capacity as president. And then in his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents for Ghana? The vice president is acting as the president. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody until it is varied or set aside. But as you know, Supreme Court decision can change at any time, provided it is policy, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Justice Tuguba openly stated that because of modern purposive approach or purposive approach, meanings can change at any time. And therefore, if you go for even interpretation and you think that the meaning has changed as a result of time, circumstances, and the purpose, you can still go back to the same court. So I am of the considered opinion that now that we have modernization, technology, and those things, that position, in future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced into 4 and Attorney General. It has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as Ordinary Act of Parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.
I'm being gagged by my chairman. He says that I've asked enough questions.
No, it's far from that. I will then proceed to give the floor to Honorable Ewa Bafo.
Thank you, Mr. Chair. The tempo has been a bit up, so let me bring it down. Congratulations, my Lord. My Lord, from your CV and your own account, before joining the bench, you practiced as a lawyer from Holy Trinity Chambers. Can you please, by way of clarification or information, let us know whether it's a partnership or a limited liability company or a company unlimited by shares?
Thank you, Chair. Chair, in Ghana, you can register a company, a law firm, as either sole proprietorship, unlimited liability, or partnership.
My Lord, I want to know whether Holy Trinity, what is its legal
sole
status?
proprietorship.
What you want, but it is the answer that the nominee wants to provide.
It was registered as sole proprietorship, and it was Dennis Adjei Legal Consult of Holy Trinity Chambers. Why we do not allow companies to be registered in Ghana as a limited liability is that once you own a firm, your liability is unlimited. Because if you dupe somebody, you use fraudulent means to take money from your client, and you say that it is limited to my shares. No, it is limited to your own properties. That is why no no country allows a company to be, a law firm to be registered as a limited liability. It can be unlimited partnership or sole proprietorship. So Holy Trinity was sole proprietorship.
Now to my substantive question. I wanted information.
You don't have a preliminary question and a substantive question, so you can either ask a follow-up.
Mr. Chair, very respectfully, the basis for my question was the reason why I sought clarification.
Honorable member, you are entitled to one question. You have asked the one question. So if you don't have a follow-up, let me give the floor to another person.
What do you make of a lawyer who maintains an interest in a firm after he has joined the bench? What do you make of it? Is it appropriate?
Honorable member, this cannot be a follow-up question. The question is accordingly overruled. I will then proceed to give the floor to Honorable Akurugu.
Thank you, Mr. Chair. Congratulations, my Lord. Yes, your students you've taught before speak highly of you, your human relation, and your command over the law. And you make law so easy. And I think based on that, I had an encounter with you, and I was contemplating going to read law. But there is this issue concerning about expanding access by breaking the monopoly of Ghana School of Law in the training of lawyers. Do you agree to this suggestion, and what reforms would you suggest for the legal education in Ghana? With regards to Makola, you go to do your LLB, then Makola. So, thank you.
Thank you very much. Yes, my Lord.
Thank you very much.
Your answer.
The legal education in Ghana is confronted with multiples of issues. Initially, we had it only at Makola, but we had emerging universities. So the students were not getting admissions. Then it was decided that we should have 2 campuses. Then we have Gimpa and Kumasi. Still, there is an issue. We have an issue. The issue about admission, even though last year the law school tried to admit about 1,400 students, but how many students are turned out from the universities every year? We used to have only 3, 4, 5 universities, and now we have about 13, including those who do this outside the country. So at the end of the day, if you look at those who sit for the entrance exam, you may get about 3,000, 4,000, and the school can take only about maximum 1,400 students. So here, there could be a policy decision. The policy decision that I read online was that why don't we allow some of the schools to do the bar, and we use the law school as we use the law school as examination center, accreditation, monitoring, and evaluation, and other departments to ensure that the integrity of legal education is not compromised. So we can have it. We can have, because it is a policy decision, and as a judge, I don't want to delve into policies, but what I will say is that if the most important thing is that if feasible studies have been done and it has revealed that this one is better than what we have now, there is nothing wrong. I will only have an issue with it where there is no feasible studies, where there's no feasibility studies, and we are just jumping the gun. But where we are satisfied that we have examined this, and this is the better option, we should go for it. Thank you.
Any further question?
Mr. Chair, no further questions. Congratulations once again.
Thank you. I will then proceed to give the floor to Honorable Anthony Imie.
Thank you, Mr. Chairman. Congratulations, nominee, on your elevation. You're almost there if you pass the test. Now, let's look at with the emergence of artificial intelligence and the spread of fake news, fake accounts, would you support the criminalization of misinformation, disinformation, and the posting of or setting up of fake accounts. Would you support that?
Yes, please, because if you do it ordinarily, it is an offense. And therefore, if you transpose it to social media, it should be an offense. Thank you.
Now, don't you see such a legislation as a threat to free speech?
No, please, Ghana, we have the Communication Act. The Communication Act has criminalized some acts. Because, for example, if you want to expose the nudeness of somebody, you are saying something that is prejudicial to the security of the state, and you do it on social media. If you do it in the country physically, it is an offense. And therefore, if you do it on social media and it is an offense, it is not an extension of anything. Assuming it is not an offense if it is done within the jurisdiction, and you do it on social media, and we are criminalizing it, that one, it will be wrong. But if you do it in Ghana, physically, it is an offense. So wherever you do it, it should be an offense.
Any further question?
Thank you very much. My next question. My Lord, recent surveys by Afrobarometer, Global Corruption Barometer, Ghana Integrity Initiative, etc., suggest a decline in public confidence in the judiciary. What specific reforms would you propose to restore trust in the judiciary?
Thank you, Chair.
Yes, Honorable Nominee.
Chair, when I was the Director of Judicial Training, we decided to make ethics a component of whatever training that we give, either to the judiciary, the judicial officers or staff. The reason is that when we are talking about corruption, we are talking about something which is bad, then we must make it a conscious effort to fight it. If you do not fight it, it will become endemic. And therefore, the most important thing is that we need to first and foremost conscientize ourselves about the effect of corruption. Then the second one, what do we do to curb it? We need education. We need training. Then one thing that people of Ghana that you don't do is that if a public officer, either me or any other person, demands money from you, you must report the person. You condone, you give it. Then when it comes to assessment, you say that you will not mention the name. Then say that the whole judiciary is corrupt. That is the problem, and it is about perception. And I can talk about personal experience as a director of the Judicial Training School. On one occasion, I was training. Then somebody came to me to complain about somebody who was taking money from him. We made the inquiries. I was then the director of the Public Complaints Unit of the Judicial Service. We investigated. The person who allegedly took the money from that person entered the courtroom and bowed to the judge. The judge did not know him. Just to give it a semblance that he had given the money to the judge and was coming to bow to show that the person who is accompanying him is the person who gave out the money to him. But it was false. So these are some of the things that we do and we must stop. In most cases, if you listen to some of the TV discussions, social media, you know, instead of bolstering the faith of people in the judiciary, we are rather saying that the judiciary is corrupt. But if you ask for evidence, then we say it is perception. So the most important thing is that we must be bold. If we have physical evidence, we must use to substantiate. Otherwise, we shall be talking about perception, because any person who goes to court and loses, the person's position is that because he did not pay bribe, he or she has lost. But it is not the matter. The case is bad. So apart from training, we need to conscientize ourselves. Then the third antidote is that if a public officer corrupts himself, that person must be prosecuted. Thank you.
Now, my last question. In your view, how should the Ghana legal system evolve to address
matters like climate change, environmental degradation, resource extraction. Let's take into consideration the current issues related to Galamsey, which has been ongoing for some time now. How should our system evolve to nip all these menaces in the bud?
Thank you, Honorable Chair. Honorable Chair, we talk about judiciary, and the judiciary, we are moving from the traditional judiciary to the modern judiciary. Now, Judicial Training Institute, we teach environmental law for judges to equip their capacities. Unfortunately, most of them do environmental law at the faculty. Law school is not done. But when they come to the judiciary, the initial training, it has been incorporated, the induction, as part of the system. Then in addition to that, we have continuous judicial education. And these are the things that we introduce to the judges. And was it 4 years ago, there was a case in Takwa where the judges was accused that the judge, somebody was involved in illegal mining. It was brought before the judge. The judge sentenced the person to 6 months. I called for the docket on behalf of the Chief Justice. I was then the director of the Judicial Training School. When it came, the police did not prefer mining offense. They preferred, the charge was trespass. So, if you haven't seen it, you may believe that the person has committed offense under the Mineral and Mining Act, and the minimum sentence ranges from 5. Meanwhile, the police who arrested that person prepared a charge of trespass. So we need to build the capacity of the judges. And when I was the chairman for the African Judicial Network on environmental law, I made sure that the selected countries, the pilot countries, Ghana was one of them. So they gave Ghana, is it about $60,000 or so, judiciary, to have a manual to train on environmental law. And I made sure that the contract was awarded to a Ghanaian. He was Mr. Asumda. He used to be the dean of Zenith. I don't know whether he's there or not. And he prepared it, we validated it, and it became the property of the Judicial Service. So these are the things that we need, because environmental degradation, air pollution, sea pollution, illegal mining, if you do not fight, it will fight us. So what I will conclude is that, yes, we need to build the capacities of the judges as well as lawyers, so that when we get cases involving those matters, we will not fall short. We will do justice to what the law says. Thank you, Mr. Chair.
Now my last follow-up question. How would you balance swift environmental protection through deportation against due process rights in criminal law?
Honorable Chair, I will use my position as the chairperson of the African Judicial Network on environmental law. We use the two together. It is a tool that you need the two. You must take drastic decisions in environmental law, at the same time pursue criminal charges against them. Because if you do one to the advantage of the other, that means those who are not within the net, they will not be caught. So ideally, we need the two to fight. It is not an alternate, it is joint. Thank you.
Thank you very much. I'll proceed to give the floor to Honorable Alhaji Omar. Honorable, you have the floor.
Thank you, Chairman. Sir Dennis, congratulations, my Lord. I want us to talk about this House, Parliament. Of late, we've been having some challenges about the privileges and immunities. And I would like you to tell this committee how best, or what are the privileges and immunities, and how best can we safeguard it. Thank you.
Thank you. Parliament is likely to lose its existence if it loses its privileges and immunities. The privileges are the additional rights that are given to members of parliament to enable them to function. That is, they must be bold and they must hold government accountable. But if the privilege is not given, or the immunity, they are not immune from acts such as being arrested. We have said that at Parliament, you have said something, then you are hunted for, you are arrested. Then that means the whole immunity is gone. You are immune from some of the laws that ordinarily would have constituted crime, but you are immune, crime or civil wrong, but you are immune from that one. Honorable Chair, let me give you an example. In 1215 AD, when the Magna Carta was signed by the dames, the barons, on the other hand, and John the King, it was 1215 AD, meaning we are ending rule by law, we are moving to rule of law. Now, when they moved, and Parliament insisted that they needed immunity, the monarch said, we will not give you immunity, otherwise we'll be at par. And they fought for 474 years until 1644, when the English Civil War. The English Civil War was brought about the rift between Parliament and the monarch. Monarch was eroding Parliament of its privileges and immunities. That was why they fought. And fortunately, Parliament was able to overpower the monarch and overthrow monarch. That was where Cromwell became the president. They changed from monarchy to republican. And when Cromwell died, his son Richard took over. Richard was also messing up. Then they went back that we should go back to the monarchy. And the future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced into for an Attorney General. It has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as ordinary act of parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.